I'm Helene from Caxton, and this video is all about POPI, or as the information regulator prefers that we call it, POPIA, the Protection of Personal Information Act. So if you will work in the media space, or in fact if you work in any other space and you would like to know more about POPI, everything that you should know, then you are at the right place, in the right place. By now you would have heard of the POPI Act, and you probably know that it will affect you in some way. You'll need to know more than that. The Protection of Personal Information Act is about, you guessed it, the protection of personal information, but I'm afraid that is where the simplicity ends. The Act is chock-a-block with legalese, and it is in fact a dictionary in its own. The purpose of this video is to make it all more understandable for the man on the street. Please note that when we refer to the Act, Act 4 of 2013, that is our primary source. And when you have the time, please take a look at the Act, because that is, after all, where the information originates from. What is the point of this video? This video illustrates aspects of POPIA in general, but it also focuses on the media space. Media companies face a unique challenge in that we have editorial departments that gather news, an activity where tons of personal information is collected. Section 7 of POPIA excludes the collection and processing of personal information for purposes of journalism from the working of the Act. What does this mean? This means that when you collect or use personal information when gathering or publishing news, you will not be governed by the same rules as the rest of the media company that you work for. Newsrooms are bound by the press code safeguards for the protection of personal information, and we'll discuss those later in this video. Firstly, let's dig into POPIA as it applies to non-editorial divisions of media companies. We'll look at the purpose of POPIA, identify key role players dealing with personal information, and we'll look at the principles that everyone should keep in mind when they are dealing with personal information. We'll look at the rights of data subject, that's all of us, and those are the people whose information we work with, that is the person who is called the data subject. Lastly, we will discuss the consequences of non-compliance, and we'll share tips on how to play it safe when dealing with personal information. First things first, what is the purpose of POPIA? We all have the right to privacy, and POPIA seeks to protect us from harm by protecting our personal information. Your personal information covers many things. The term personal information describes information relating to an identifiable human or information relating to an identifiable entity. It includes your contact details and your addresses. Your medical records are most definitely part of your personal information because it contains information relating to you. Documents in digital format or hard copy that contain information about an identifiable personal entity will once again be personal information. Let's look at some examples. Your identity document, your identity number, that's personal information. Your address, once again personal information. The same applies to your business registration details, contact details, and information about my location, my name, and my surname. The Act states that various other information is personal information, and it's a long list, so just take a look at Section 1 if you want to know more. POPIA requires us to follow certain rules when dealing with personal information, and that is in order to avoid the unfair use and abuse thereof. We'll now look at the key role players involved when personal information is dealt with. A data subject is the person to whom personal information relates. In other words, if you have my telephone number, I will be the subject of that data, so I'm the data subject. If you have my name and surname, that data once again relates to me, making me the data subject. A responsible party refers to a public or private someone that determines why personal data is obtained or processed. An operator will be the person processing personal information on behalf of a responsible party in a justifiable way. Now, POPIA is new to us, and all South African companies must take reasonable steps to ensure that their various divisions and branches comply with the Act. We must all play our part. Every employee and manager must ensure that they act justifiably when dealing with personal info. Luckily, there are people and resources available to help us, and I'm going to share more details on that with you now. That's where another term comes in, Information Protection Officer. An Information Protection Officer is someone at a company or business who is responsible for POPIA compliance. This person ensures that information on the Act and how it works is circulated through the company. They are also responsible for ensuring compliance in general. They empower employees and management with policies and know-how they need to ensure that everyone deals with personal information in a fair and justifiable way. This way, employees and managers at different branches and divisions of every company will be able to deal with queries and questions on personal information. Each company or business's Information Protection Officer must register with the Office of the Information Regulator. If nobody at your business has been registered that title, the head of your business will automatically become the Information Protection Officer. If you are an Information Protection Officer and you don't know how to get hold of the Information Regulator for registration, because remember you must be registered, then you should visit www.justice.gov.za/inforeg/. I will put that address in the comments on this Facebook video so that you can ensure you are registered. Just once again, very important, every company has an Information Protection Officer. If you don't have one, then the head of the institution automatically becomes this officer, and you need to be registered with the Information Regulator by July 1st at the latest. Who is this Information Regulator? South Africa's Information Regulator is a body tasked with monitoring and enforcing POPIA compliance. They issue very helpful guidance notes to assist members of the public and information protection officers. So if this is all new to you and you want to know how to deal with this and what your information protection officer should be doing, then you can go to the website of the Information Regulator. They've made some really helpful guidance notes available. I will share the URL of their website in the comment section of this video as well. You can also search the terms Information Protection Officer Guidance Notes on Google and you will find a copy. It's been really helpful to me and many others. Note that the Information Protection Officer will also be responsible for the implementation of POPIA compliance. That is the Protection of Access to Information Act. Now, in terms of this act, certain entities need to have procedures in place where information is requested from the entity. The Human Rights Commission used to administer POPIA compliance, but this also now falls under the jurisdiction of the Information Regulator. Next up, we'll look at some key principles when dealing with personal information. A data subject, remember that is a person to whom data relates. A data subject may object to having their personal information processed. They can, in other words, say no. And in order to obtain or process personal information after July 1 or on July 1, you will need a data subject's consent. This may sound like stating the obvious, but personal information is also processed for a reason. And when you want to obtain or process a data subject's personal information, they need to know the reason why. You need to communicate that to them. When you deal with personal information, the purpose is communicated and you will agree upon certain conditions that limit what you may do with this data. And the data subject has the right for these conditions to be respected and adhered to at all times. The data subject must know that their personal information will be handled safely and responsibly. Companies have rules when it comes to the handling and storage of personal information. For example, you will file documentation safely in offices that are locked every night. Online records are usually kept safe using tools like firewalls and passwords. The data subject must know that they can contact the company at any time to have their personal information updated and that they have the right to request it being deleted or destroyed. Companies must not hang on to personal information for longer than it is required. Once you've used it for the intended purpose, and if you no longer need it for legal or financial requirements, you must destroy it. If you've acquired a data subject's personal information for one purpose, and if you seek to then use it for another purpose, you will need their consent all over again. If you need to pass along someone's personal information to a third party in order to achieve the purpose for collection, this may be done as long as the data subject's rights are honored at all times. You must follow the principles of lawful processing when dealing with personal information, and you should take reasonable steps to ensure that your personal information records are always accurate and up to date. Be open about your practices and implement security safeguards when dealing with personal information. Remember that data subjects always have the right to go to the information regulator or to take legal action if their rights have been abused. What happens if you contravene POPIA? Complaints may be instituted with the information regulator and investigations may follow. The outcome could be an enforcement notice or even criminal prosecution. And in a worst-case scenario, non-compliance could result in jail time or a fine to the tune of millions. How do you play it safe? In a nutshell, know the rules and stick to them. Go to the information regulator's website and download their guidelines today. These are really helpful. As promised, we'll now take a look at what newsrooms must do when it comes to POPIA. The Act acknowledges that newsrooms collect and process personal information for the purposes of journalism. When you do so, and if you do so in accordance with Clause 4 of the Press Code, you will be exempted from the POPIA Act. This is what Clause 4 says, and I'm going to read it word for word. Protection of personal information. The media will take reasonable steps to ensure that the personal information under their control is protected from misuse, loss, and unauthorized access. The media shall ensure that the personal information they gather is accurate, reasonably complete, and up to date. The media shall take steps to verify the accuracy of their information and, if necessary, to amend it where a person requests a correction to be made to his or her personal information. The media shall only disclose sufficient personal information to identify the person being reported on, as some information such as addresses may enable others to intrude on their privacy and safety, and the media shall inform the affected persons and take reasonable steps to mitigate any prejudicial effects where it is reasonably suspected that an unauthorized person may have obtained access to personal information held by the media. Seems like a lot, but it comes down to if you collect or use personal information for the purposes of journalism, do so ethically and lawfully. Don't use more than you need to for the purpose of either gathering or publishing news in the public interest. If you do that, you will be exempt from the Act and just stick to the Press Code. I really hope that this was a helpful guide and that we'll all be compliant and ready come July 1.